The state of Karnataka released the draft Karnataka Platform Based Gig Workers Social Security and Welfare Bill 2024 on June 29th. The bill aims to protect the rights of platform based gig workers and establish obligations for aggregators. This makes Karnataka the second state after Rajasthan to create a law exclusively focused on the social security of gig workers in India. The state government invited feedback for the bill and received responses from worker unions as well as advisories. These comments also showed the conflicting takes of various stakeholders when it came to the drafting of the bill. To understand these conflicts as well as the nature of this bill, we will be speaking with MediaNama journalist Vallari Sanzgiri, who has been closely covering developments in the gig economy space. Vallari, can you give us some background and a quick summary of the bill?
Yeah, thanks, Simon. So, like you mentioned, the Karnataka bill is a social security welfare bill, and it's quite similar to the older Rajasthan bill, except there are certain clauses and provisions mentioned in the bill that are not there in previous schemes. So, for example, it specifically talks about some government guidelines for fair contracts that should be given to or suggested to the aggregators that are sometimes called or treated as employers in the bill. Now, what this basically means is that there will be a guideline of sort that aggregators will have to follow. That will have to be government approved in order for them to hire gig workers. This by itself is actually quite a controversial topic that a lot of stakeholders have commented on. I'll get to that later. But in the same spirit of looking at this entire gig economy in sort of an employer-employee relationship, the bill has also added some provisions like they have given the workers things like the right to refuse work. What this basically means is that from the bill's perspective, they are thinking that, say, the gig workers get a contract and the contract mentions, say, five assigned tasks for a day. Uh, if a gig worker gets more than five, say seven tasks or something for a day, the gig worker has the right to refuse the extra two tasks that are given to them. So that is one right that is mentioned in the bill itself. There is also a clause on the termination of work, which was not really there in the previous bills in as much detail, at least. So what this basically says is that there will be certain grounds based on which an aggregator will be allowed to remove a gig worker, and they will have to specify this grounds. If they do not specify this ground, the gig worker has the right to raise a grievance to the relevant authority regarding this, and they also have a right to terminate the work on their own terms as well. There is also another provision that talks about the need for a notice. So, suppose a gig worker has a contract, there are certain changes in the contract. According to the bill, they have to notify the gig workers, the aggregators have to notify the gig workers about this change in their contract within 10 days of the change, or I think that is the rough time estimate within which they have to inform the workers. So, uh, from the aggregator and gig worker relationship, these are sort of the starking changes that they have made. They have also mentioned, and this is not new, but they have asked for a registration of the gig workers. Now, the new thing here is that it seems to be a responsibility for the aggregators as well to make sure that the gig workers are registered and that they get a unique ID from the government for this. And also the fact that the welfare board, which is basically the board that will overlook the functioning of this bill and the provisions mentioned within it, they also have to make sure that there are two databases. One is a, a database that checks the registration of gig workers, and the other is a database that looks at the registration of the aggregators. So these are the two things that the welfare board especially has to keep a look at. And in terms of the composition of this welfare board as well, in the Rajasthan bill, the composition was much bigger. There were a lot many more members in this bill, but within the Karnataka bill itself, it seems that it is much more. Basically, they want a smaller board. It seems the number of gig worker representatives, I think, is also much lesser. It's one or two gig workers only. So again, these are like the small things that differ from the Rajasthan bill. But a big change that they have also brought in is that they have mentioned that every aggregator, which has more than 50 platform workers, they will have to create something called an internal dispute resolution committee, and the gig workers can go and approach the committee itself. They don't have to go to any other grievance redressal mechanism. But suppose that they are not happy with the decision that is made by this committee, they can then go to the mechanism stipulated by the Industrial Disputes Act of 1947. Again, the interesting part here is this industrial act that they are talking about. It looks at an employee-employer relationship. And again, as I mentioned, some of the stakeholders have an issue with this perspective of the bill because they feel that a gig economy differs from what a traditional employment looks like. And of course, there are some penalties mentioned in the bill itself, like the aggregator, if they do not adhere to the uh, provisions in the bill, they will be liable to say 5,000 to a lakh rupees penalty, which will worsen by 5,000 every day if they keep failing to adhere to the provision that has been raised as a contention. Largely, these are the points. There is also the point about the welfare fund and fee. So again, the idea of a welfare board, welfare funds and fees is not new. But what the Karnataka bill does is that it has mentioned that this fund, which is basically meant to be for the benefit of the workers to make sure that they are able to avail whatever social security scheme is optionable to them. It states that the aggregator has to contribute to this fee, the passenger has to contribute to the fee, and even the gig worker himself or herself or themselves has to contribute to the fee. So in certain parts, it is much more detailed as compared to the previous policies that we have seen in India. And in certain parts, they also mentioned the transparency. So again, what happens is when you register one, now that they have given the workers a right to reject and a right to terminate work, uh, what they want to look at is how exactly these tasks have been assigned to the gig workers. So they have now called for a transparency mechanism which will help the government, or rather the board, understand uh, how an aggregator is assigning work, how it rates the gig workers, and how it decides the exact payment of a gig worker. And this the gig worker can also access in case they want to know how these things are being done because it directly affects their income. Again, this is from a very specific employee-employer relationship. So these are largely like the big things that have popped up in the bill, and a lot of people are taking a closer look at the bill for these reasons, I feel.
Right. So you mentioned this briefly, but as you said, the government has called for stakeholder comments, and we have seen, a lot of unions and industry associations have expressed their feedback. So what have you gathered from this?
So it was quite interesting actually. If I make a comparison between the Rajasthan bill and the Karnataka bill, there are some long-standing complaints by the gig worker unions that I think have not been addressed, or rather will be addressed maybe in future consultations. For example, in the previous Rajasthan bill itself, the unions had raised concerns about the autonomy of the welfare board because there are a lot of government officials that are in the board, and unions felt that there should be ex officio members independent bodies, representatives within the welfare board rather than ex officio members. And some concerns about defunct gig workers still remaining in the system and thus availing schemes that they feel the defunct members should not be given access to. So these are some long-standing concerns, but specifically about the bill, uh, unions have raised an issue with the definition, some definitions in the bill. So one thing is that they want a very clear stipulation that these workers will be workers that are hired by platforms, digital platforms, and no one else, because they feel that that is the correct identification for gig workers. Um, and in the same vein, they feel that if the grievance mechanism is related to the Industrial Disputes Act, the act should also now be amended to include gig workers and aggregators in the employee and employer definitions respectively. So these are very specific changes that they have demanded regarding the definitions itself. And interestingly, from the other side, other stakeholders have raised issue with these definitions, saying that they're too broad. So, for example, NASCOM had sent in its comments and it had said that uh, it does not make sense to include to define gig workers and aggregators in the manner that it is done, because they feel it is again going into the employer-employee relationship. And since gig workers are not working on a day-to-day 9 to 5 basis where they get a very specific salary at the end of the month, so they feel that making these kind of definitions is just going to complicate the entire economy, and they feel that these definitions should therefore be reduced and not broadened. And something worth mentioning here, to be fair, is that when the previous analysis of the Rajasthan workers bill was going on, some of the experts had in fact said that the definition uh, used in the Rajasthan bill, which is very close to the Karnataka version of the definition, it does not adequately encompass the entire gig economy, because there are workers who do very menial jobs like labeling and stuff, and they are not included in the definition. Even if we consider the schedule within the bill that stipulates all the services that will be recognized for a gig worker platform aggregator, basically, it includes stuff like healthcare, which is a sector and not a service by itself. So this entire section about what exactly a gig worker means, that is something that is under contention. And that comes from both sides, from the gig workers wanting it to be in more of an employer-employee perspective, and the aggregator circle itself saying that it should be from a more open uh, gig perspective where the traditional employment system does not work. Um, Another thing that they had raised an issue about was the welfare fund itself. So, like I mentioned, the bill has a welfare fund that everyone has to contribute to. Now, according to IFAD, because there is no specification on how much contribution should be done by each entity. According to IFAD, there should be a levy of not more than 2% of a ride fee for a passenger, because it does mention a passenger. And for aggregators, the contribution by them should be no less than 2% of their quarterly income, quarterly turnover. And on the other side, NASCOM says that the contribution by aggregators should be no more than 1% of their annual turnover, should be a minimum of their annual turnover, and no more than the 2% of their annual turnover. So there are some very opposing views about the contribution by aggregators on this front. Uh, but to be fair, they have also said that a one size fits all idea would not work for all the gig economies that are out there in India. So they are open to a consultation on this front. But again, this is something that I feel will lead to a tussle maybe in the future as to how much contribution should be done by each entity. The union even says that gig workers should not be compelled to contribute to the welfare fund at all, because they are already under a lot of financial duress. Uh, Regarding the welfare board, they have mentioned that gig worker representation should be more. This is from the union, and this representation should come from from the national union that is currently recognized by the government. Mm, and also an extension for the number of board meetings that are done. So they want a quarterly meeting system rather than annual meeting system. But again, whether or not that will be accepted is a different thing. Now, one very interesting things where I see a lot of tussle is the rights of gig workers. NASCOM has very interestingly said that the obligations for aggregators to give a notice to gig workers whenever there is a change, for them to give them an explanation on why they are being terminated, the right of a gig worker to reject work, all of these things, according to them, are unnecessary, because they say that the way that gig work operates all of these rights and privileges are already embedded within the system itself. So there is no real reason to have a separate provision specifying these things. That is NASSCOM's view. But the gig economy, or rather the gig union at least, has not made any comments on this topic at all. Instead, what they have said is that in case of raising grievances, uh, gig workers should be allowed to raise the grievance via a representative. So basically, what their point is that a gig worker may not be very well versed with how a legal uh, procedure for raising a grievance works, right? It's not very accessible to them. So if they use another representative to raise a grievance, that should be okay, and that should be included within the bill itself. From a very policy perspective, on the other hand, IAMAI has asked the government how exactly the welfare fund is going to equate into the social security schemes. So basically, how will the fund be used to ensure that the benefits are given to the gig workers? That is something that they want to know, because they say that that is the basis on which we can actually give a suggestion as to how much contribution should be done by each entity. Um, and they have also raised contention against this employer-employee perspective that the bill has taken, warning that it can lead to certain issues in the gig economy in the future, that it will hurt the sustainability of a gig economy if you uh, restrict the gig economy within the traditional employment system. Another interesting point they had raised was about the processing of gig workers' data. So again, to go back a little bit, the welfare board has asked the aggregators to share a lot of data relating to the entire gig system, which even includes the personal data of a gig worker that is with the aggregator. Now, this very obviously it overlaps into the data protection law of India, but there are no clarifications within this draft version, at least for now, as to how a person is supposed to navigate both this bill and the data protection law. So stakeholders like NASSCOM and IMI have warned that there should they should not be aggregators should not be compelled to share personal data of the gig worker. Data should be shared by the gig workers themselves because it's their data. And they have also asked that this demand for a transparency as to how the rating system operates, how the money is dispersed and calculated for gig workers, this should not be shared with the board, because the board is going to include uh, aggregators from competitor, uh, is going to include members from competing aggregator companies. So, there could be Ola, Uber, there could be Zomato, Swiggy, different kinds of representatives of all these companies who are basically competitors. So they have said that this idea of how exactly their mechanisms work, that is proprietary information, it should be confidential to the company and should not be shared by the board. The official statement, in fact, that they have given is that this would be intruding on the operational work of companies. So they have specifically asked that these ideas should either be discussed or removed from the bill entirely. And lastly, I think I mentioned notice. So they have said that you demand from aggregators to specify why someone has been removed from work and stipulate a time frame within which this notice needs to be given. But so NASSCOM says that you have not considered what an aggregator is supposed to do if a person uh, has done something that goes into, say, something like violence or assault, and the gig worker needs to be removed on the spot. So what happens in those cases? These are some of the comments sent in by the stakeholders themselves.
All right, Valerie, thank you for that. So what has been your analysis of the bill?
So like it keeps popping up, it seems that the bill wants to take a very traditional approach of this entity is an employer, this entity is an employee, and it wants to run with that. but I see a lot of issues. I do agree to some extent with what NASCOM and IAMI say about taking this kind of an approach for a gig economy might create issues, because uh, it's not just the aggregator that might suffer, even workers might suffer if they are forced to go into a very traditional 9 to 5 mentality of work, especially in gig economy. But on the other hand, I also don't know to what extent I agree with the idea of removing provisions like the right to reject work. So, for example, we have recently covered how Amazon India, or sorry, rather, urban company workers have been getting work auto assigned to them. And that has already started creating a lot of problems for a lot of workers, to the point that they have started protesting in Bengaluru. So, clearly, this bill, according to me, needs a lot of discussion by various stakeholders. And I do agree with a very common demand made by all stakeholders that this bill cannot do with just a 10 working day period for receiving consultations and feedbacks. NASCOM, in fact, suggested a 45-day timeline for all the stakeholders to analyze the bill, come up with their comments, and maybe hold a discussion where they can actually bounce ideas off of each other and figure out how to frame the bill. That makes much more sense to me. So, hopefully, maybe the Karnataka government will listen to this advice by entities, which even includes think tanks like Internet Freedom Foundation. So, a lot of stakeholders have in fact asked for an extension of the timeline. I think it would make sense for the government to heed these demands by the workers, by the stakeholders.
All right. Thank you so much, Valerie. For more such quick takes, please check out MediaNama's YouTube channel. And if you would like to learn more about this and tech policy in general, please check out MediaNama's website. Thank you.